right. Hi, everyone. My name is Hannah. I work with Family Source Consultants, and we are here today joined with Chelsea Caldwell, a fabulous attorney. We're going to learn a lot about parentage and the legal process and how it all relates to both intended parents and surrogacy in general. So, welcome, Chelsea. Thank you so much for taking the time with us today.
Thank you. Thank you for having me. I'm so happy to be here.
Absolutely. Can you start by just telling us a little bit about, I know we were kind of chatting before we jumped on here, but just tell us a little bit about kind of your background, what your practice currently covers, and how you got into it in the whole first place.
Yeah, sure. So I'm a family law attorney. I've dedicated my law practice to assisted reproductive technologies, or ART. I'm a founding partner of my law firm, Midwest Fertility Law Group, and together with my other two partners, Meg Lediber and Tim Schlesinger, collectively we're licensed in 7, almost 8 states across the Midwest and South. So we focus exclusively on ART and help clients worldwide seeking to build their families through methods such as surrogacy, gamete donation, and embryo donation. Our practice has a broad geographic reach, but I myself am physically based in Northeast Arkansas, close to Tennessee. And then my other two partners, Meg and Tim, are physically based in Chicago and St. Louis, respectively. And as I was just telling you a moment ago about how I got into this, I actually developed my interest for assisted reproduction while I was in law school. A lot of my colleagues in the field had primarily practiced in other areas of law and then found their way into art law. My journey into this started at the very beginning. And during my first year of law school, I was undergoing IVF purposefully and had twins during my second year as a result. And had a mentor that told me about Quad A, an organization of assisted reproduction attorneys, and that they had conferences and I should check it out. And then my IVF doctor also told me there was only one attorney at the time in the state that was doing this work. And so both of those happened pretty simultaneously. And so I attended my first Quad A conference during my first year of law school, and then kept attending conferences and spent a lot of time researching and writing about the topic of assisted reproduction. Now have 2 law review articles that have been published by law review journals. And so I knew from the very beginning this was what I wanted to do.
Wonderful. So do you feel that your experience then with IVF yourself has impacted, I mean, obviously it impacted your choice to go into the field, but now that you're actually in practice, how does that impact your work on a day-to-day basis, having that background?
It's not necessary that a professional has to have that experience, but it just provides such a appreciation for the whole process that my clients and our clients go through, because you can understand what all that involves, but until you've been through it and you've experienced all of those feelings and the fear in going through IVF and spending all of this money and basically putting your hope that we're going to go forward with all these efforts and hope a baby results out of it. I mean, it really helps you appreciate what clients go through to get to that point, and gives you an appreciation for that as well. And so I think it has definitely helped my understanding and appreciation of what clients go through to get their baby.
Yeah, thank you for sharing that. I cannot imagine law school and IVF and twins on top of all of that. So.
It was amazing. Yeah.
So can you, I know you mentioned that you're licensed in 7 states. Which 7 states are you licensed in then?
So I'll start with my firm and where we're licensed as a firm. And that those states are Illinois, Arkansas, Kentucky, Tennessee, Oklahoma, Missouri, Texas, and then we're pending Wisconsin. Individually, I'm licensed in 4 of those states: Arkansas, Tennessee, Kentucky, and Texas.
Okay. Wow. So this kind of leads into the next questions. why should what states an attorney is licensed in matter to an intended parent or a GC who's looking for an attorney?
Yeah, so where an attorney is licensed matters as it pertains to an IP or GC, because in terms of surrogacy, the laws regarding surrogacy vary state to state. So it's important that at least one of the attorneys involved in a surrogacy arrangement or agreement are licensed in the state in which the surrogate plans to give birth, in order to be able to verify that the IPs will be able to be established as the legal parents in that state, and that they'll be able to obtain a birth certificate in that state listing them as the legal parents.
Excellent. So then you said specifically that it's where the surrogate is going to be giving birth. So if the surrogate's giving birth in a different state than the intended parents, would you recommend that that intended parent look for an attorney in the state where they currently reside, or what does that process typically look like that you would recommend?
It just depends based on the certain set of circumstances. As kind of as a default general rule, if you've got one attorney that is involved in the contract that is licensed in that state where the birth is going to occur, that attorney will be reviewing the contract to make sure it's compliant with that state's law. Some IPs choose to hire an attorney that's in that state, and then the GC will also have an attorney in that state. Some of the times they prefer to have an attorney somewhere else draft a contract, and then the surrogate's attorney will review the contract based on that particular state's law. And then also, depending on what choice of law is more favorable, or which state's law is more favorable, that's another reason why they may opt for an attorney in a different state as well. It just depends on the circumstances of the case.
Yeah, that absolutely makes sense. And just a reminder for folks watching, because we are live right now, and this will be recorded for later viewing as well. If you do have questions and you're watching now, feel free to drop it in the chat, and we're able to jump in with some of those questions later. But we'll continue with some of the other questions that I had prepared in advance that I'm so curious about. So Chelsea, can you just tell us a little bit then about, I know you'd mentioned that some states are kind of more amenable to surrogacy than others. So what does that look like in a legal standpoint? Like, what would make a state more surrogate friendly than another?
So what makes a state surrogacy friendly as applied to a particular set of facts for a case, in my opinion, depends on two things: whether a secure process exists in that state for establishing parentage, and then also the ease of that process. Usually, most of the time, we hear states classified as surrogacy friendly or not, or ranked as most surrogacy friendly, depending on whether the state has enacted legislation permitting surrogacy. There are a number of states that have, but there are many more states that have not enacted legislation, but still have a method to establish parentage that allow us to have predictable certainty that we'll be able to continue to establish parentage in that same method for future cases. Some of the states that have enacted legislation that permit surrogacy provide certainty that, yes, by statutory law it's protected, but there's still a lot of requirements and hoops to jump through in order to be able to obtain that court order and a birth certificate. And then the states that would be considered not surrogacy friendly would be states that outright prohibit surrogacy or offer no method to establish parentage with a particular set of facts of the case.
Yeah, I'm so curious about, you said like enacted legislation. Do you think that it's specifically like they just haven't gotten around to it yet, or are there like legal reasons why a state might choose not to enact such legislation?
Enacting legislation is just such a daunting process, and it's very difficult to do, especially given the political climate that exists in any given state. Even regardless of the political climate, it's still difficult to enact legislation that actually passes, that both sides are happy with, that vote on passing. I think it's great the states that have, but in some states where the political climate is not so ideal, I don't know that they'll ever get around to it, so to speak. I would like to say that's the answer, but there are just a lot of hurdles in the way to overcome in order to get there.
And you've been involved in that process as well, right?
Yes, I have.
Can you share a little bit more about that experience?
Yeah, so I was involved in drafted legislation in Tennessee to mandate infertility insurance coverage. And so we submitted a bill that would have potentially done that. And just having that experience was really invaluable, but really gave me a perspective of how difficult enacting legislation is. And we made it through several committees and did very well. It was a pure grassroots movement, and I can't say enough good things about the group that had the efforts to do that, Tennessee Fertility Advocates. And really, overall, they've just created a community for people to go to that are going through IVF. That's just really amazing to be a part of. But ultimately it didn't pass, but there may be another effort in the future. But I was involved in it, happy to be involved in it, and it gave me a really big appreciation for that.
That's amazing. I think it's great to know too that there's just folks out there fighting for this sort of opportunity for so many people. That would be really impactful.
Mm-hmm.
We have a few questions that are coming from the group now. So one of which is that you mentioned states can be ranked as being surrogate friendly. Is there a particular organization that does rankings, or any more, like where can people find more information about?
Good question. And really, I meant that more informally, that sometimes you'll, be browsing the internet and you'll find, lists that say, okay, California is the most surrogacy friendly state you can go to. Yes, they're surrogacy friendly, but is their process easier than Arkansas? I would probably say no. So you seem to find states that are repeated to be, and you hear over and over again, is this is where you have to go. But really, there are many states that are surrogacy friendly. So I'm not aware of any organization that officially ranks them. I just said that more informally, as sometimes you may find when browsing the internet or Googling.
Yeah, there are rabbit holes on the internet, I'm sure. But are there particular states then that don't have a way for IPs to establish parentage, and which ones are those?
The states that prohibit surrogacy, so Louisiana, Michigan, there's really no way to establish parentage there. Some states, even such as Tennessee, for example, Tennessee bases whether we can establish parentage on genetic connection. So we have to have at least one parent that's genetically related to the child in order for us to be able to establish parentage in Tennessee. So if we have a double donor situation with a donated embryo and a surrogate is involved in our gestational carrier, there's no way for us to establish parentage. So it can vary based on states that prohibit surrogacy, and then also state specific, given the certain set of circumstances that we're faced with in a case.
Sure. And I know that from my experience with Family Source specifically, they are checking for some of those things off the bat. So even before the matches happen and things like that, these conversations are definitely happening behind the scenes.
Right. And we tell them and everybody else that even before those matches are made, call us, let us help in making those matches, and let us consult with IPs, GCs, and make sure that we'll be able to establish parentage prior to the match proceeding and going to contracts or being medically cleared, etc.
Mm-hmm. So from like a logistical standpoint, then the match is made, and then there's a few other steps, but legal's one of the next steps. So when you get a new client, then either an intended parent or a GC, do you just provide a kind of standard contract? Do you start with a conversation? What does the process look like from your end?
Usually when we're given a referral, most of those come from agencies, I mean, agencies are such a vital part of the process, and it just makes it uh, so much better all the way around when agencies are involved. Their work is so important in a match, but usually when we're provided a referral, we do an initial consult with the client, and then if they engage us whenever it's time to start the contract process, then if we're drafting, we have a standard draft, and every other attorney has a standard draft as well. That draft is revised based on a number of items, based on the case, such as choice of law that applies, the parties that are involved, whether there are two IPs or a single IP, whether it's a single or married GC, the views, opinions, and preferences of the parties, and so on.
And so that sounds like a lot of conversations and back and forth then.
Mm-hmm.
Yeah. So, are there like frequently asked questions then that you hear from intended parents or from the surrogate side of things as you're drafting things that typically come up?
Yeah, there are. From the intended parent side, I would say one frequently asked question is, as an intended parent, how can I estimate the total cost I'm going to be paying? Or what's my full obligation to pay medical expenses? That's a frequently asked question. And then our answer to that usually is, while the IPs are ultimately liable for covering and paying for all uncovered out-of-pocket medical expenses that are related to the pregnancy, there's usually a limitation on that the expenses have to be related to the pregnancy or the efforts to become pregnant or any resulting complication. And then there's usually a limitation on how long their obligation to pay those expenses lasts after the birth of the baby. But that's a frequent question because, the intended parents want to have some expectation on how much the entire process is going to cost.
Mm-hmm.
And then I would say another question we frequently get is from IPs would be, what if the surrogate changes her mind? This is something we routinely hear, and ultimately that's the worst case scenario. Also very rare, especially considering that for the most part, a majority of surrogacy journeys are gestational surrogacy, meaning that there's no genetic connection between the surrogate and the baby she's carrying. That significantly reduces the risk that a surrogate would want to keep the baby. And then another component that reduces that risk is having an agency involved. And as I said earlier, agencies play such a critical role in recruiting GCs, vetting them, speaking to them, making sure they're educated as to the purpose and process, and in the right frame of mind before considering them as a potential candidate to match with intended parents. But ultimately, it's not a spot anybody wants to be in, but it's why there's a contract in place to help protect the parties and why we also get a court order. And then from surrogates, I would say their overall main concern of surrogates is having a thorough understanding of the requirements that the contract has. The contract is drafted heavily to include a lot of requirements that a surrogate has to comply with, a lot of things she can and can't do. So it's important that the surrogate understand what those are so that she remains in compliance with the contract. And that would be items such as travel restrictions, pregnancy restrictions, obligations to notify intended parents, and how to submit medical bills, and so on.
What are some of the repercussions then? So I know you spoke about if the surrogate changes her mind, but if the surrogate's going along, just fine, but then doesn't fulfill all of those requirements, what does that look like from a legal perspective?
Well, from a legal perspective, that would be a question of whether she is in breach of contract. Ultimately, probably as it pertains to a majority of the items in a contract, we can't specifically enforce a surrogate or force a surrogate to do or not do what she has agreed to do in the contract. And so really the only remedy left for the IPs is to sue for breach of contract and hope to recover some damages from that. But ultimately, we can't force a surrogate to comply.
Hopefully that's not a terribly common occurrence.
It's not. It's not.
That's good to reassure folks. Typically, in my experience, it's a lot more of a straightforward process than I think I think I was nervous going in as a surrogate myself to kind of the legal process and not understanding all the ins and outs of it. But having a great attorney, I think, is really helpful in being able to ask those questions.
Right. And I will say that, at the end of the day, everyone wants the same thing. And so, you as a surrogate, you wanted to deliver that baby. You wanted to give the intended parents that baby. I mean, everybody has the same goal. And so that helps to reduce situations where we're faced with a breach of contract most of the time.
Mm-hmm. Are there any common mistakes or pitfalls you've seen either intended parents or surrogates kind of fall into in the legal process?
Pitfalls or mistakes.
General advice like that, for folks who are just starting the process now?
I would say there's a large amount of trust that both sides have to put into the process, and that is as it pertains to their dealings with the agency and why certain things are in place that an agency may require, or the legal process why certain things have to be done. And I would say that sometimes you find that IPs or GCs will get wrapped around the axle on specific details, or they won't just have a trust in the process and the professionals that are guiding them. And that's what we're here for. And we're here to protect their best interests as well. And we do this every day. And so I would say that would probably be a common pitfall that I see. That doesn't happen very often, but just trusting the process and the professionals that are guiding you.
Mm-hmm. I understand that it's probably easier said than done, but I absolutely agree with that. Well, great. And just one more reminder to folks watching, we're going to be wrapping up here in a few, but if you do have questions that you'd like to ask, you absolutely have the opportunity to do so. You just put them in the chat and we'll make sure that we get to them. So we do have another question that was popped into the chat. So just again about logistics of the different states. So if an intended parent lives in a state that doesn't have a way to establish legal parentage, as long as the surrogate lives in a surrogate-friendly state, they should be good to go. Is that correct?
That's correct. Because that state, and usually most of the time, the state in which the surrogate lives is the state where the birth is intended to occur. Ultimately, I would say it's the state in which the birth is intended to occur, where that delivery is going to be, because that's the state that's going to be issuing the birth certificate. And then normally that's the state that you would get a pre-birth order or a birth order from, that would establish the legal parents as parents of the child. And that's regardless of where the parents live, whether that's in not a surrogacy-friendly state or whether that's international, which most other countries prohibit surrogacy internationally as well. But there's still a process for them to establish parentage when they return home by working with a lawyer in their home country after they've completed the legal process here in the States. But yes, you're absolutely correct that it's really ultimately the state in which the surrogate lives and where the birth is planned to occur.
Yeah, it's like you're reading my mind. I was just going to ask about international IPs and how that may be different than even just folks who are in the States. Anything else to share specifically about the process as it relates to international IPs?
Really with international, it's just so important that they are working with an attorney in their home country as well, that once they've completed the legal process here, that they can then work with that attorney to establish their parentage in their home country. And actually, that process doesn't wait until they've completed it here. It starts at the beginning because, and we always recommend they consult with an attorney in their home country at the beginning, because there are certain countries that require certain specific language in the pleadings that we're filing that they'll use once they return home, that we need to know about ahead of time so that they don't have any issues arise. And then other than just establishing parentage, most international parents need a passport or a way to get the baby back home from the United States, back home with them. And so the process is a little extended after you establish parentage. We've got to get a birth certificate, apply for a passport, and then some countries, some parents need apostilles of birth certificate or other certified copies of court orders. It's just dependent on the country and what they need so that they can establish their parentage once they return home as well.
Mm-hmm. Yeah, and it's great that you kind of have a partnership with folks all over to make that process as easy as possible.
Yes, it is. It's a great network that we're able to be a part of.
Mm-hmm. We did have one more question in the chat. So the question specifically is about, I think I'm understanding the question correctly. You said that the state, so intended parents need one attorney, surrogates need another attorney, but the intended parents don't need an attorney where the delivery is to happen and in their state. Is that correct?
It just depends again, and I know that people are probably so tired of hearing lawyers say that answer, but
everything depends.
It really does depend on the states that are involved. So if you, for example, some states require that both attorneys that are involved in the contract be licensed in that particular state. Colorado, for example, is a state that has surrogacy legislation. It requires that the attorney representing the intended parents and the attorney representing the surrogate be a licensed attorney of Colorado in order for that agreement to be in compliance with the Colorado statute. So yes, in certain circumstances, yes, both attorneys need to be in that state. There are other states with statutes that don't require that. But it doesn't outright limit you from some of the time from selecting an attorney of choice, given that we as attorneys have the ability to have counsel arrangements with attorneys that are licensed in that state. So we can potentially bring in an of-counsel attorney to review and serve as that in-state attorney if necessary, or if the parties prefer as well. But ultimately, it's just dependent state to state, whether and the circumstances of the case, whether both parties need to have attorneys that are in that state. I would say, as a general rule, most of the time, the surrogate's represented by an attorney that is licensed in the state in which she lives and where the births are planned to occur.
I see. I didn't know that. I learned a lot. This is very helpful.
Probably more information than you wanted to know, but I'll go back to it depends.
Yes. Well, it sounds like the real answer is, if you're with an agency already, speak with folks at the agency and they'll be able to kind of guide you. And then if you reach out to an attorney, they can let you know if they're able to help or refer you to someone in another state, again, because of that network. Does that sound about right?
Yep, that's perfect.
Fantastic. All right. Well, with the 1 minute that we have left in our time today, are there additional topics that maybe we haven't gotten to that you'd like to make sure that our viewers are able to learn a little bit more about?
No, I think that we've covered a pretty broad range of topics. I mean, if anybody has any other questions, I'm happy to answer those.
Fantastic. Yeah, I'll give folks just another second just in case, but Chelsea, I really do appreciate the time so much. Thank you for, again, your expertise and us being able to rely on you as a resource. We really appreciate it.
Absolutely. And thank you so much for having me again.
All right. Have a great rest of your day. Thanks, everyone.
You too. Thanks, Hannah.